Welcome to Starting a New Practice. I'm Christine Bilbrey, and I'm a Practice Management Advisor at the Practice Resource Institute of the Florida Bar, also known as PRI. We are bringing you the CLE to help you start your own law firm. Whether you're a brand new law school graduate or you've decided to go it on your own after years at the big firm, we are here for you. This CLE over the next 2 hours is going to bring a series of subject matter experts talking broadly about the things that you need to consider as you start your new firm. When you are finished, I encourage you to come to the PRI website where you can find a wealth of free resources, administrative forms, and our checklist that has the real details that you're going to need to cover as you start your business. We have free member benefits at the bar site, and you can get free incorporation for your firm. We have free legal research. We have a lot of wonderful discounts on legal technology, services that you're going to need for your firm. So take advantage of that, watch the CLE, and then reach out to us at PRI.
Hi, good morning. My name's Hal Thayer. I'm an assistant director at the Florida SBDC at the University of Central Florida. SBDC stands for Small Business Development Centers. And we have a network in the state of Florida that includes more than 20 offices in cities around the state. All of them are connected with a institution of higher learning and are available to help local businesses, both startups as well as established businesses, to start, grow, and succeed. The offices are staffed with certified consultants. I'm a certified consultant who have gone through a rigorous process to create a full repertoire of expertise and skills to help people starting businesses or managing businesses. The SBDC in general offers three important services. First is consulting, and we offer that at no cost. So you can go to the SBDC Florida website. You can complete a request for counseling and determine the office you want to be counseled or consulted by. And a consultant will be back to you within 24 to 48 hours to arrange a phone call, a meeting, whatever you require, since it's your meeting. And then sit down with you and help you with the matters or the issues, the challenges you're facing. We cover everything from how startup costs, working capital, cash flow management, marketing, the full gambit of business issues for our clients. Along with consulting, we offer a variety of seminars and workshops designed to train entrepreneurs and small business owners and attorneys who are starting their business in a variety of topics. It's Google AdWords, how to get found on the internet, ways to maximize your sales process, marketing strategies, strategic planning, all part of trying to help those small businesses and help you to be as successful as you can be. Thirdly, we have a set of databases that we can access through our university affiliates that can offer a vast array of market research options for you as you look at your market. If you are looking for a certain kind of business that you'd like to make a prospect, we can go into a database and identify names, titles, addresses, phone numbers, so that you've got a quality prospect list to pursue as you wish and as part of your marketing plan. So SBDCs across the state, there to help you, in general at no cost. There may be a small cost for some of the seminars and workshops, but really de minimis, and I'm talking tens of dollars, not hundreds of dollars. So it's consulting, it's training, and it's database resources are the primary offerings by the SBDC. With respect to how do you start a business in the state of Florida, first and foremost, we would recommend that you prepare a business plan. And in conjunction with that, a marketing plan. And with both of those, a budget. There's plenty of research that shows that having produced a marketing plan improves your likelihood of success by almost 50%. We like those kind of odds, so we are very intent upon helping people write their own business plans. And I say write their own business plans because it's imperative that you write your plan and that I don't write your plan. The reason that is that however good your business plan is, however on target you are, when you get out into the real world, you're going to find that things are different than you expected. And when you run into those kind of challenges, you are much better prepared to meet them if you are the author of your business plan. You know what you thought would happen, and therefore you know what kind of adjustments you can make inside of your business to be effective, to be successful, to meet that challenge. So step one, writing a business plan and a marketing plan. We've got plenty of templates that we can make available to you at the SBDC. There's softwares, we have training in it. And then after you've written it, and when I say written, we're not looking for A papers. We're looking for you having made the best effort you could to draft a business plan. And at that point, we can be very valuable to you. Our consultants can be very valuable to you in helping you go over your business plan, fill the holes, answer questions, and make it as robust and useful to you as possible. Step two of starting a business in Florida is to set up a business entity. I spend a lot of time explaining to non-attorneys that there are legal entities and non-legal entities that people can use to do business. So as you all know, sole proprietorships and partnerships are not legal entities in the eyes of the state. They are contractual obligations on the partnership side, and a sole proprietorship is just doing business. On the other hand, there are legal entities important to most of the small business world because they provide limited liability protection. And those are C corporations, S corporations, and limited liability companies. I'll tell you, choosing which of those is right for you is a complicated question. Our recommendation is, as you're looking at that, is that you sit down with your accountant and talk about each one to get clear on what the tax consequences are. Because a C Corp is treated differently than an S Corp is treated differently than an LLC. And you want to be sure you know what those tax consequences are before you make your decision. My next recommendation is that you go to a URL vendor like GoDaddy and find a website address that works for your company, for your business, for your firm. It sounds like an odd step, but you want to get that first before you go seeing if the name you want is available in the state of Florida. So second step after the talking to your accountant, go to GoDaddy or another URL vendor and find a name you want. Thirdly, you go to the Florida's Secretary of State website, which is at sunbiz.org, and you do a search to see if the name you want is available. There are lots of names already taken, so you need to check. You want to make sure that whatever name you're choosing isn't too close to another name on the list that's taken, because the software won't tell you that it's too close. It'll let you register, and then you'll get a letter 3 weeks later saying, oops, too close, you've got to have another name. And 3 weeks later is after you've started a bank account, bought checks, created business cards, spent a lot of money that is going to make you very unhappy to find out that that name is not available. If you have doubts about it, if you think you might be too close, we recommend you call the Secretary of State's office and talk to them about and get a ruling from them as to whether it's too close. So while I've got you at sunbiz.org, you've found the name you want. You don't go anywhere. You stay on sunbiz.org and move over to register that name as a corporation, S Corp, C Corp, or LLC. It's very simple. The only thing that's required is a credit card. They will ask you to supply information. Be aware that your home address can be the company's address, that you can be the agent for your company or LLC. Sometimes you get bombarded with information to suggest you can't, and it's false. You can be all of that inside of your registration of the business entity. Once you've paid the fee, which I think last I checked was around $140, you're in business. You've got a registered business entity in the state of Florida. LLCs particularly are very easy to manage. The state generously sends a postcard to remind you to file an annual report. The filing of an annual report is comprised of you going back to sunbiz.org, again with your credit card, and telling sunbiz.org that you are still in business. Oh, and paying them some more money. It's that simple. After you've got the name registered with the state, the next recommended step is to get a federal employer identification number, sometimes called an employer identification number, FEIN, EIN, whatever it is. Essentially it's your social security number for your business, so that you can separate your personal finances from the business finances. And to get that, you go to irs.gov and look for obtaining an EIN, and essentially it's 5 minutes of information and you're done. You've got your number. So now we've gotten the business plan and the marketing plan in the works. We've got a business entity established. You've got a federal employer identification numbers to do business. I would say for an attorney, the next step would be to look at preparing whatever forms are necessary for the formation of the firm if you're not a solo attorney. That is to say, if there are partnership agreements that need to be prepared, buy-sell arrangements, bylaws to the firm, for the firm, any of those kind of choices. I think after you've gotten your company established, that's a good time to work that out with your partners in the company. And so next step is to obtain what's called a county or municipal occupational license. This is the county's opportunity to find out that you're doing business in their jurisdiction and to collect some more money. simple call to your county tax collector's office to find out what is owed and what the process is, and then I think there's a form and a check you need to drop off with them, and that's an annual charge. And so another step is obtaining the municipal occupational license. I guess last is you need to register with the Florida Department of Revenue. There's a DR1 form that you are going to want to complete that essentially lets you know and lets the Department of Revenue know what kind of, whether you need to file a new hire report, whether you will sign up for the reemployment tax, which used to be called the unemployment tax. But it's an important step in an important final step in establishing the firm. One tip I'd offer that isn't always front and center for people is that a lot of companies, and I'm sure law firms, can be really dragged down by all of the back office stuff, payroll, payroll taxes, HR issues, employee manuals, employment benefits. And I'd bring to your attention companies called professional employment organizations, PEOs. Who will perform all of those functions for you, honestly, at a pretty reasonable cost. There are a number of them out there, so you can get competitive bids. I have a number of clients who are law firms who swear by their PEOs. I also have $10 million clients who use PEOs. So as you're getting into that whole hiring and having employees and starting to think, how the heck am I going to pay them, and what kind of benefits do I need to give them, and what do I need to do on the HR side, a professional employment organization is really worth your consideration. I hope this has been helpful. I hope that you take advantage of the small business development centers across the state. We have a lot to offer. We do it at a very reasonable price. I did say no cost, didn't I? And we'd welcome the opportunity to work with you.
Hi, my name is Frank Rodriguez, and I'm the founder and chairman of Corporate Creations. I've been asked by the Florida Bar to present this brief video to assist members of the Florida Bar in setting up their own corporate entities for the practice of law, either as sole proprietors without any other partners or in combination with other attorneys that you want to practice law with. On the Florida Bar website, there is a member benefits section that provides benefits in being a member of the Florida Bar. And one of those member benefits is free incorporation services for your entity for the practice of law if you are a member of the Florida Bar. And if you go to the Florida Bar website, you can see a link to this member benefit for free incorporation service. And this service is provided by the company that I founded in 1993, Corporate Creations. During my brief presentation today, I'm going to cover the 5 entities or business structures that are permitted under the rules regulating the Florida Bar for the practice of law. And I'm going to list those 5 structures for you, and then I will go over each of them one at a time, describe them, and provide you with a summary of which ones will be more beneficial depending on your situation. The 5 structures are as follows: sole proprietorship, general partnership, limited liability partnership, professional association, and professional limited liability company. All 5 of those structures are permitted under the rules regulating the Florida Bar. And I'll point out that a limited partnership, which is different than an LLP, is not permitted for the practice of law. So let's start off with sole proprietorship. And let me define what a sole proprietorship is. A sole proprietorship is a business set up for the practice of law that has not incorporated and where there is only one owner. So if you start your own law practice and you do not file any document with the state, the law considers you to be running your law practice in the form of a sole proprietor. One of the drawbacks to operating your business in the form of a sole proprietor is that if you have any employees within your law practice, you have complete liability for the conduct of your employees. So for example, if you have an assistant and that assistant gets into a car accident on the way to deliver a FedEx package to the court, that person is operating under the scope of your employment, and that car accident will result in a liability against you personally. And by operating as a sole proprietorship, you have no protection against the kinds of liabilities and risks that exist out in the world. I highly recommend against operating your law practice in the form of a sole proprietorship. And now you know, if you've already started your law practice and if you have not filed the registration of an entity with the state, the law considers you to have a sole proprietorship. Now I'm going to cover the structure called a general partnership. A general partnership is a business set up for the practice of law that has 2 or more owners. Those owners are commonly called partners. So if you are in the practice of law with anyone else and that person shares in the profits of the law practice, then you have a general partnership under state law. In a general partnership, you do not need to file any document with the state. The mere existence of a law firm that has not registered any document with the state where there are 2 or more owners constitutes a general partnership. Remember that I recommended against running your law practice in the form of a sole proprietorship, and that advice goes doubly so for a general partnership. In a general partnership, each partner has joint and several liability for all of the liabilities of the partnership. So for example, if you own 90% of your general partnership law firm and your partner owns 10%, and anyone within the law firm, or if anyone who is your partner commits malpractice, then the liability can be imposed entirely on you, regardless of the percentage of the law practice that you own. So it is extraordinarily risky to operate any business of any kind, including a law practice, using the form of a general partnership. Let's talk now about LLP, Limited Liability Partnership. Many years ago, there was a major accounting firm in the United States that was structured as a general partnership. And one of the audit partners in that accounting firm was accused of committing malpractice. That resulted in a major lawsuit against the partnership. And every single partner in that accounting firm ended up having to either personally declare bankruptcy or had to dig into their own savings in order to pay a portion of the liability, even though many of them did not know the partner who had been accused of the malpractice. As a result of that major accounting firm having this financial problem, the legislatures around the country started passing laws permitting the establishment of a limited liability partnership in order to insulate partners in what was otherwise a general partnership structure. So it is now possible for you and one other person, or you and multiple partners, to file a partnership registration statement with the state of Florida that officially recognizes your law firm as a general partnership, and then you simultaneously file what is called a statement of qualification. And by filing the statement of qualification, you convert your general partnership into a limited liability partnership, which commonly ends in the letters LLP. And by doing so, you are no longer jointly and severally liable for the liabilities of the business structure. It is an improvement over the general partnership because you are now protected from personal liability for the risks associated with the law firm. And the only risk that you can never protect yourself against under any of the business structures that I am describing today is your own personal malpractice. So the formation of an entity protects you against the conduct of other people. It protects you against the conduct of your partners, and it protects you against the conduct of your employees and any contractors you do business with, but it does not protect you against your own personal malpractice or your own conduct. So the only way to protect yourself against your own conduct or your own malpractice is by having insurance. So I highly recommend that even if you practice law in the form of an LLP, that your firm seriously consider having an insurance company provide you with malpractice insurance. Now I'm going to cover the fourth type of business structure, and that is a professional association. A professional association is essentially a corporation that is used for the practice of a profession. And the practice of law is considered the practice of a profession. The ending of an entity that is set up as a professional association is typically the letter P and the letter A, standing for professional association. And again, a professional association is a corporation governed by Chapter 621, which governs professional associations, but also governed by Chapter 607, which governs corporations in general. By forming a professional association, you protect yourself against the conduct of anyone else who is a shareholder within the professional association, what otherwise would be called a partner if you were in an LLP context. And the professional association also protects you against the conduct of employees of the law firm. One of the things that you can do with a professional association that you cannot do with an LLP is you can choose to have your professional association taxed as either a C corporation or as an S corporation. The default is a C corporation. So if you file articles of incorporation and you include the provision stating that your corporation is going to be used for the practice of law, that puts the entity under the professional association provisions, and you then have the ability to file what is called Form 2553, which allows you to make the S corporation election for your professional association. So if you do not file Form 2553 with the IRS, then you have what is considered a C corporation for tax purposes, and you would file Form 1120 with the Internal Revenue Service at the end of every tax year. And if you do file Form 2553, it's a very simple one-page form that informs the Internal Revenue Service that you and your colleagues, or you alone, because it is possible for you to be 100% owner of your professional association, that the owner or owners of the PA have made the decision that they want to be taxed as an S corporation. With an S corporation, there is only one level of tax at the shareholder level. The entity becomes a pass-through entity for tax purposes. There is no taxation at the corporate level when you have the S corporation election. And one of the benefits of making the S corporation election is you can engage in a tax strategy that is called wage reduction. And wage reduction is a legal way to reduce the amount of money that you pay in Social Security and Medicare tax. The combined rate in the United States for Social Security and Medicare tax is 15.3%. 12.4% of that is Social Security, and the balance, 2.9%, is for Medicare tax. And this is a payroll tax. Everyone in the United States who receives income in the form of compensation for services provided is required to pay this tax. And one of the nice things about making the S corporation election is you have the ability to pay yourself a lower amount in pay and pay yourself a profit distribution. And under U.S. tax law, profit distributions paid to owners of an S corporation are exempt from Social Security tax. So for example, if you reduce your total pay and you are the only owner of the corporation in the example that I'm giving, and you reduce your total pay by $10,000, you would save about $1,530. I multiplied the $10,000 by the 15.3% tax that you save by reducing your pay from whatever you're paying yourself to some number that is $10,000 lower. Now, the logical limit to this is that you pay yourself compensation of zero, and I highly recommend against that course of action because the Internal Revenue Service has the right to argue that you were paid unreasonably low compensation, and the Internal Revenue Service will make the effort to recharacterize the profit distribution as really being pay in disguise. As long as you use discretion and judgment and rely on the advice of your tax counselor, you will be able to successfully implement the wage reduction tax strategy in compliance with IRS regulations and at the same time save some money on Social Security and Medicare tax. And always remember that when you start your law practice, the faster you can develop positive cash flow, the faster you will have financial stability and the more you can practice on building your law firm. The final type of business structure that I will discuss today is called a professional limited liability company. A professional limited liability company is governed by chapters 621 and chapter 605 of the Florida statutes. And a professional limited liability company is formed by filing articles of organization with the state, much like a professional association is formed by filing articles of incorporation with the state. When you file articles of organization with the state to form your professional limited liability company, you have essentially created an entity that can choose its tax attribute. So there are only 4 ways that business structures can be taxed in the United States: as a disregarded entity, as a partnership, as an S corporation, or as a C corporation. A professional limited liability company is the only business structure that exists in the United States that allows you to select any of those 4 tax schemes for purposes of running your law practice. And so in my view, the most flexible and most beneficial way to structure your law practice is a professional limited liability company. Do not make the mistake of using the letters LLC as the name ending of your law firm. If you do that, you will be violating Chapter 621. The Florida Secretary of State does not police against this mistake, and you will create reputational risk for yourself because anyone who understands the law will conclude that you do not understand the law, and that will not be good for your career. So make sure that if you are practicing law and you decide to form a professional limited liability company, that the name of your firm end in the letters PLLC so that you are in compliance with Chapter 621, which governs both professional associations and professional limited liability companies. If you choose to have your PLLC taxable as an S corporation, and remember that you can choose to do that with either a PA or a PLLC, you would then file Form 2553 so that your PLLC will be taxable as an S corporation. And once you've done that, the tax return that you would file for your PLLC is Form 1120S. So any entity taxable as a C corporation files Form 1120, and any entity that is taxable as an S corporation files Form 1120S. That is the Internal Revenue Service form, and those forms are due after the end of the tax year, and they're generally due by March 15th. So 1 month earlier than your personal tax return of April 15th. With a professional limited liability company, you can have an entity of entities. So you could, for example, have a professional limited liability company, taxable as a partnership, which would mean it would file Form 1065, and then each of the individual partners within the PLLC could choose to have their own tax structure. So you could have a professional limited liability company that is owned by another professional limited liability company that chooses to be taxed as an S corp, and you may have another partner who may choose to have their PLLC, which owns the main PLLC, taxable as a C corporation. There are some situations where it would be beneficial to be taxable as a C corporation instead of an S if you have very high health expenses that are not covered by insurance, or if you have very high health insurance premiums. And the reason for that is that in a C corporation, you can deduct 100% of health insurance expenses and health insurance premiums, whereas in an S corporation, there are certain limitations in that deductibility. In the final analysis, unless you have higher than usual health expenses, you will generally benefit by operating your law practice with a professional association taxable as an S corporation if you choose to go that route, or if you choose to go the route that I recommend, professional limited liability company, taxable either as a partnership if you want each of the owning entities to choose their own tax structure, or as a S corporation itself if you're only going to have a one entity structure. Remember that at the Florida Bar website, when you look up member benefits, you will find a member benefit of 100% free basic incorporation services for the formation of any entity that you choose to form if you are a member of the Florida Bar and if you form the entity for the practice of law. And that is a service provided by Corporate Creations, which is a firm that I started in 1993 and is now the third largest registered agent company in the United States. We consider lawyers at law firms and lawyers in legal departments of corporations to be our clients. We are here to serve the Florida Bar community that has been very loyal to us over the last 23 years of business. I hope this information has been helpful. If you go to corporatecreations.com, you will see an article called Starting Your Own Law Practice that we provide as a service to members of the Florida Bar. That information is provided free of charge, and I encourage you to visit that website in order to refresh your memory on some of the points that I have covered during my brief remarks today. I wish you success in your career, and I'm available to answer any questions from any member of the Florida Bar as a favor, as my way of saying thank you.
I'm Elizabeth Tarbert. I'm Ethics Counsel for the Florida Bar in that position since 1997. Today we're going to talk about some common issues that arise from an ethics and advertising standpoint when lawyers start their own practices. So one of the first issues that lawyers need to think about is what kind of entity their practice is going to take. So the rule for that is 4-8.6A, and it's the authorized business entity rule. It basically allows lawyers to have any form of business organization that's permissible under Florida law for professionals. So for example, a lawyer can have a sole proprietorship, a general partnership, a limited liability partnership, a limited liability corporation. Anything that is properly formed under Florida law for professionals, generally speaking, is going to be permissible under the Florida Bar rules. A lawyer also has to be aware that they have to also comply with Florida statutes, not just our rule. Another common question that arises when a lawyer starts their practice is, what can I use as my firm name? Obviously, the traditional law firm name of the names of the lawyers who are shareholders or partners in the firm is perfectly permissible. Firm names just cannot be misleading. So, for example, if it were me, I could be Elizabeth Tarbert, attorney at law. If I formed a partnership with Mr. Smith, I could be Tarbert and Smith. Notice I put myself first. If I have a PA, it would be Tarbert and Smith PA, or Law Offices of Elizabeth Tarbert PA. The other thing that lawyers often ask is, do I have to use my name as part of my law firm name? And the answer is no. Trade names are allowed in Florida. Of course, like any other kind of advertising, a firm name can't be misleading. So a trade name, if a lawyer wants to use a trade name, can't be misleading. A way in which it could be misleading is if it sounded something like as if it were a governmental office. So if I wanted to call myself the Justice Center, that sounds like it could be something other than a private law firm. So if someone asked, could I have such a name, I would generally advise that the person use some form of disclaimer like a private law firm so that people know what the entity is. The other thing to be concerned about with a trade name is the lawyer, if they advertise under a trade name, have to actually practice under that trade name. So that it has to be the name that they use everywhere. So it has to be on the lawyer's letterhead, business cards, office signs, and together with the lawyer's signature on pleadings for documents that are filed in court. So again, we don't care if people want to try to get the alphabetic advantage in the telephone book, which is kind of obsolete, by saying they're AAA aardvark attorneys. But if you're going to do that, that has to be the name that you practice under so as not to mislead the public. We don't want people using multiple names and members of the public not knowing who they really are. The third question that we often frequently get is, where am I going to have my office? What do I do for office space? Lawyers, particularly when they're starting out, don't necessarily have a lot of money, and they say, do I have to have a physical office in Florida? Unlike a lot of other states, we don't actually require that a lawyer have a brick and mortar office here in Florida. Lawyers are perfectly welcome to practice out of their homes as long as they're complying with any requirements, ordinances, et cetera, in their local community. So a lawyer can practice out of their home. Lawyers often ask us, well, what do I do if, don't I have to, when I advertise, give my full address? I don't want my home address to be on advertisements. The answer is no. The rules don't require a lawyer to have their full physical address. What the rules do require is if lawyers advertise, they must include their office location where they practice law, where they have a bona fide office to practice law, which can include the lawyer's home, by city, town, or county. So for me, the minimum information I could have in an advertisement would be Elizabeth Tarbert, Tallahassee. I don't have to give my full street address. I can just say Tallahassee. Lawyers often also ask if they can share space with others. Can I share space with other lawyers? Can I share space with a non-lawyer? The answer is yes, you may. There are certain ethical issues that arise when a lawyer shares space with others, whether it's lawyers or non-lawyers. One issue is the avoiding of misleading the public. So if a lawyer is sharing space, the lawyer has to have separate office signage for the law office. Another issue is solicitation. If the lawyer shares a receptionist with a non-lawyer or shares a phone line, that phone line has to be answered in a neutral way, such as professional offices. That avoids the issue of having customers of another law firm or a non-lawyer be solicited by the receptionist for the lawyer. Confidentiality is a huge concern, of course, when lawyers share space with others, whether it's lawyers or non-lawyers. The lawyer has to make sure that they take special efforts to ensure confidentiality of client information. That means don't share a local network with other people that are not in your law firm. Don't share a computer network with the real estate office next door. Make sure that you keep your files locked. Make sure you have a conference space where you will not be overheard by others when you are talking to your clients. Just a few little precautions like that, just to make sure that you are keeping your clients' confidences. Another question that we get particularly about home addresses when lawyers are practicing out of their own home is, do I have to give my home address to the Florida Bar? The Florida Bar does require that a lawyer give a physical address, but that does not mean that that's necessarily the address that the lawyer has to use as their official bar record address. So although the bar wants a physical address, why? So we can serve you, of course, if we get a complaint. We don't require that be the information that the bar provides when the public calls for information about a lawyer. So a lawyer could have a P.O. box, which is what they use. For example, if they have a home address, if they're practicing out of their home, they can use a P.O. box as their office address. That can be their official bar record address as long as they also give a physical address to the bar. And while we're on that topic, once a lawyer decides after starting their law practice where their office space is going to be, you need to make sure that you update that information with the Florida Bar. There's a rule that requires that a lawyer keep on file with the Florida Bar at all times their official bar name, their official bar record address, including email address. Office signage, that's a frequent question that comes up. What about office signs? Well, again, if you're sharing space with someone, either another lawyer or a non-lawyer, you need to make sure you have your own office signage. Like every other form of advertising, office signage can't be misleading. So you would generally have to follow the bar rules. If it's a true office sign, though, we don't require that you file it for review. So lawyers then often ask us, well, what do I do to get clients? Well, most law firms have a website. There's something like 80% of lawyers in the state of Florida have a website. That's sort of a basic information that isn't expensive for a lawyer to have to provide the public with information about him or herself or about their law firm. So with a website, a lawyer has to follow the general lawyer advertising rules, but a website does not have to be filed for review. So generally, it would be things like, of course, the name of the lawyer or law firm has to be on the website, the office location by city, town, or county. A lawyer can't say anything that's misleading, nothing false or misleading. The lawyer can't promise results, can't have information about past results unless they're objectively verifiable, and all the other panoply of rules that I'm not going to go into today. That would be a whole nother webcast. And again, generally advertising generally to get business is, again, perfectly permissible in Florida. It's just that there are rules that lawyers have to follow when they do it. Unlike a website, most advertisements in Florida have to be filed for review. So any information that a lawyer conveys to the public about their legal services can't be false or misleading and has to follow the general requirements. So that includes things like billboards, radio ads, TV ads, signage, bus bench ads, car wrap ads, any form of advertising about the lawyer. It includes social media accounts if they're used to provide information about legal services. Obviously, if you're on Facebook just to talk to your family and friends, the bar really doesn't care about that. But if a lawyer, say, is on LinkedIn to provide people with information about their legal services, then that has to comply with the rules. Social media sites, just like websites, generally do not have to be filed for review. Another thing that lawyers need to worry about when they're forming a new law firm is conflicts of interest. It's very important when you start a law practice to set up a good conflicts checking system. Lawyers are bound by the rules, and when you're practicing together with another attorney in a single firm, your conflicts are going to be imputed to each other. So it's very important to start a conflicts checking system as soon as you open your law firm. And it could be as simple as index cards, although that's a little antiquated, or it could be information that's put on the computer that's searchable. That's probably a little easier and a little more 21st century. It's just important to make sure that you note when you represent a client, the client's name, the names of all parties that are in that particular matter that you're representing the client, and their roles in the matter. It often is a good idea if you are dealing with a corporate client to also name all the principals in your conflicts checking system. So the president of the company, say, if there's a general counsel or someone else that you deal with on a regular basis on behalf of the company, that would be a good person's name to put in your conflicts checking database. Another frequent question that we get has to do with trust accounts. The very first question is, do I need one? Because not all lawyers do need a trust account. A lawyer needs a trust account if the lawyer takes any money from a client or a third party that doesn't belong to the lawyer. That has to be held in trust. So that would include things like if you represent clients in real estate matters and a client gives you earnest money to hold to transact a sale, that is money that has to be held in trust. If a client gives a lawyer an advance on fees, it hasn't been earned yet. That has to be held in trust. If a client gives a lawyer a deposit for the lawyer to pay costs out of in the matter as it goes along, that is money that doesn't belong to the lawyer. That is money that has to be held in trust. So anytime a lawyer gets any money from a client or third party that's connected to representation, it must be held in trust, separate from the lawyer's money. When does a lawyer not have to have a trust account? when they don't accept any money that doesn't already belong to them. So, for example, one situation where that might arise is lawyers who do immigration work and criminal defense frequently charge nothing but non-refundable fees. Non-refundable fees are earned on receipt. It's the lawyer's money. The minute it leaves the client's hands and comes into the lawyer's hands, it belongs to the lawyer. So if the lawyer charges nothing but non-refundable flat fees and doesn't take deposits or advances on costs from clients, then that lawyer might not have to have a trust account because they're not accepting money. Another way in which lawyers handle that is either by making the client pay the costs directly, or by the lawyer advancing costs on behalf of the client and only accepting money from the client when the costs have already been paid out by the lawyer, so the funds are currently due and owing to the lawyer. So if the lawyer never accepts any funds in connection with representation, the lawyer doesn't have to have a trust account. And there are certainly lawyers in practice who manage to do that. The second question that relates to trust accounting that's a frequent question is an IOTA account. An IOTA is interest on trust account. That's a situation where the interest that's being made on money that's held in trust on behalf of clients or third parties actually goes to the Florida Bar Foundation and is used for indigent legal defense. Not all trust accounts are IOTA accounts. IOTA accounts are only for short-term or nominal funds. That is, funds that are held for either such a short time or at such a small amount of money that they can't generate beneficial interest for the client. So the lawyer has to use the lawyer's own independent professional judgment in making that determination. The lawyer has to decide, is this something that could earn interest for the client? If it can, it doesn't go into an IOTA account. It goes directly into a separate interest-bearing account where the interest accrues to the benefit of the client. And if the lawyer has multiple clients in that situation, usually what the lawyer does is sets up a single interest-bearing account at the bank that has sub-accounts that are counted to each individual client for whom the lawyer is holding funds where the interest will accrue to the benefit of the client. Under no circumstances does the lawyer ever get the interest. That's actually in the rules. So an IOTA account would be where it's short-term or nominal funds, and it's really a situation where those funds can be, when they're aggregated together, they can earn beneficial interest, but on their own, they really can't. That's the only reason the court allows lawyers to aggregate that money, and the money goes for indigent legal defense. If it can earn beneficial interest for the client, the lawyer's a fiduciary, they should be doing that for the client. A related question that comes up all the time with trust accounts is, when I open a trust account, do I have to notify the Florida Bar? The answer is no. You do not have to notify the Florida Bar when you open a trust account. What you do have to do when you open a trust account is you have to have a letter on file with the bank that tells the bank to notify the Florida Bar if a check is returned from the trust account for insufficient funds. So that is an important piece of administration that has to occur with a trust account, but it has nothing to do with notifying the Florida Bar when the trust account is opened. With an IOTA account, the lawyer should notify the Florida Bar Foundation, so the Florida Bar Foundation knows to look to receive money for the interest that comes on that account. Lawyers can also contact the foundation before they open a trust account and talk to the foundation about how to set up an IOTA account and different interest rates at different banks. The foundation's very knowledgeable about that. It is a separate entity. It is not the Florida Bar. So when lawyers are contacting the foundation, it is a separate entity, and they contact that entity directly. A question that frequently arises when lawyers are opening their own practice is actually kind of backing up a little bit, and that is, how do I leave my old firm? What happens with the clients? Do they come with me? Do they stay with the firm? And the answer is, that's the client's choice. That's not up to the lawyers involved. Clients are free to choose their own attorney. What the bar rules do require, though, is that if a lawyer is departing from a law firm, or there is any other reason why there's a change in firm composition, it could be a firm is dissolving, it could be that somebody is leaving and going to another firm or starting on their own. So under any circumstances where there's a change in firm composition, the important thing from the bar's perspective is to protect the clients. So the clients have to be notified of the change in the firm's composition. The preferred method is a joint letter from the firm and the departing lawyer that informs the client of the lawyer's departure. So the rules require that lawyers negotiate with their firm from which they're departing, engage in good faith negotiations to have a joint letter. Now, lawyers then ask us, well, what happens if the firm won't negotiate? Or what happens if we can't agree on what form the letter should take? If that's true, if both sides have engaged in good faith negotiations, then either side can send a separate letter if they choose to, if they can't agree on what a joint letter would say. Now, if you can agree on a letter, then it can say whatever the two of you agree to. If you cannot agree, however, the bar rules do require that the unilateral letter take a certain form. It has to provide certain specific information. And that includes telling the client that they have the options of either going with the lawyer who's departing, staying with a law firm, or choosing their own lawyer that's related to neither of those parties. The other thing that the letter has to indicate is if there is money being held for the client at the firm, that how the lawyer proposes to handle that issue. It also has to tell the client that the client might be responsible for paying to have copying costs for the file, because the file actually belongs to the law firm, not to the client. The file that the lawyer or the law firm creates on behalf of the client. Now, if the clients don't choose either way, if the clients say nothing after a letter's been sent out, the rules say that the presumption is that they remain clients of the firm. Another thing to be aware of when lawyers are starting a firm is what do you do when you have new contracts with lawyers, say you want to hire somebody. One thing that is important to remember is the bar rules prohibit covenants not to compete. It's Rule 4-5.6, and it's actually called Restrictions on Right to Practice. The rule is not about protecting the lawyer's practice. It's about making sure that clients have the right to choose whatever lawyer they want. So when a lawyer is employed by the firm, the lawyer and firm can't make an agreement that if the lawyer leaves the firm, the lawyer can't compete with the firm. So no geographic restrictions, you can't practice in Orlando, no time restrictions, you can't practice in family law for the next 2 years after you leave the firm. That's prohibited by the rules. If a lawyer is lucky enough to be in a position to be able to hire another lawyer, if you're opening your own practice, the lawyer should be aware that they have responsibilities for their subordinate lawyers. It's Rule 4-5.2. It requires the lawyer to make reasonable measures that the lawyers are complying with their obligation under the rules of professional conduct. And for the subordinate lawyer has to make sure that their own conduct complies with the rules of professional conduct, and they will be responsible for their own conduct even if they do something that's being ordered by a superior lawyer, somebody who's their supervisor or boss. That lawyer is still going to be responsible if it's a clear area of ethics. If it's a gray area, the rules allow a reasonable resolution by the supervising lawyer, but if it's very clear, it doesn't matter whether the lawyer who's a subordinate acted at the direction of a supervisor, that lawyer is still responsible for the violation of the rules. Similarly, lawyers who are supervisors also have responsibility if they're lucky enough to have support staff. They're responsible for the conduct of their support staff. Non-lawyers, their conduct when they're operating in a law firm has to conform to the rules of professional conduct in the same way as if they were a lawyer. So it's very important for lawyers who supervise non-lawyers to make sure those non-lawyers understand what those ethical obligations are. One of the most important ones is confidentiality. It's not the human condition not to want to talk about things, but that's an important hallmark of the attorney-client relationship is the keeping of information confidential, not disclosing information about the client. So that's an important concept to make sure that lawyers get across to the non-lawyers that they supervise, because it's not intuitive and it's not natural. So the lawyer needs to make sure they're taking reasonable efforts to make sure that their non-lawyers understand what the ethical obligations of the lawyer are and conform their own conduct to that. For that reason, it's a really good idea to have a written staff manual when you have a law firm. You can set forth some of those things. You can provide a copy of the rules. You can provide non-lawyers with copies of ethics opinions that have been written about what non-lawyers are permitted to do and not do in a law firm when they're under the supervision of a lawyer. And it's an important chance for the lawyer to give specific, clear direction to non-lawyers about what conduct they expect from the non-lawyer. One last thing that's important for lawyers to remember to do, and that is lawyers are required to have an inventory attorney. All lawyers who are members of the Florida Bar, except I believe government lawyers, are required to have an inventory attorney. If a lawyer leaves a law firm, it's important to update who the lawyer has designated as their inventory attorney, because if you're at one law firm, usually the inventory attorney is going to be somebody else in that same law firm. Once you leave the law firm, you can't really assume that the other lawyer is still willing to be an inventory attorney, or for that matter, that you would want them to be your inventory attorney. The inventory attorney is someone who comes in and winds up the lawyer's practice if the lawyer is disabled, dies, or is could be because they're suspended or disbarred, they're unable to practice law and unable to wind up their own practice. So the inventory attorney system allows another lawyer to step in basically to the shoes of that lawyer and wind up their practice, make sure their clients get the help they need. It might be moving those clients to another law firm or another lawyer. Sort of a frequent corollary question that we get is, if someone designates me as their inventory attorney, do I have to serve in that capacity? The answer is no. Obviously, we would like lawyers to go out and find someone who would be willing to serve in that capacity, but the bar can't force someone to be an inventory attorney. We do have systems of volunteer lawyers who have agreed to be inventory attorneys, and the bar will find someone to act in that capacity if the person you've designated does not want to serve in that capacity, or if you're the person someone's designated and you don't want to serve in that capacity. Those are just some of the general questions that often arise when a lawyer opens up their own practice. Any other kinds of ethics questions that lawyers have, they are free to call the ethics hotline. That telephone number is 800-235-8619. There are lawyers who are members of the Florida Bar who give ethics advice to other lawyers. It's paid for by the bar. It's paid for by your bar dues. It's a service the bar offers to try to help its members stay out of trouble, and so we highly recommend that you use it. With the ethics hotline, it is open from 9 a.m. till 5 p.m. Monday through Friday. Lawyers must, in order to get an opinion, lawyers have to be calling about their own future conduct, and it has to be an ethics question. We are not the Civil Procedure Department of the Florida Bar.
Hi, my name is Ken Burke, and I'm going to talk to you today about trust accounts. Now, each lawyer who is taking in money and holding it for another party has to make sure that they establish a law firm trust account. And this is different than a trust instrument. This is a trust account, and under the bar rules, these trust accounts have to be maintained and have to be maintained using the rules which are specified. Each attorney should look to 5-1.1 and 5-1.2 and thoroughly read those items. They're not long rules, but they're very important that you maintain those trust accounts in the way standards called for by the Florida Bar. I, unfortunately, at one time served on a bar grievance committee. That part wasn't unfortunate, but the unfortunate part is that a lot of the violations involve the attorney's trust accounts. So it's really vital that you're familiar with the rules and that you follow those rules. And that's what I'm going to try to help you with today on how to establish them. When you establish your firm, it's important that you set up not only your bank account for your firm, but also setting up a bank account that's called a trust account. Your law firm name with trust account afterwards. The bar rules are very specific. It has to use those words. It can't say escrow account or some other type of a name that sometimes the bank suggests to you. They must say the trust account. The whole purpose of the trust account is to take monies which are not yours, which are client monies that you're holding on their behalf to be used for some purpose, usually in the future. A purpose like a deposit, a real estate deposit on a contract, or it could be your retainer fee, which you're going to be earning in the future. It would be housed in your law firm's trust account. And when you establish this account with the bank, you have to notify the Florida Bar Foundation because these accounts are called IOTA accounts. That stands for Interest on Trust Accounts. And the interest that's generated from these accounts, which are small in nature, the amounts of the deposits that you hold in there are small in nature or transitory, where they could be a larger amount, but you're just going to hold them for a few days, and the interest earned, which normally would go to your client, it's too costly. It doesn't make sense for it to go into a separate account, so it goes into this trust account that you have for your law firm, and the interest that's generated from that account goes to the Florida Bar Foundation to fund some of the worthwhile projects that they do on a statewide basis. So that's important that you notify the Florida Bar Foundation, that your bank also notify them that an account has been established. The record keeping, and the record keeping is very important on the trust account. And these are things that you have to establish with your bank first off. Many of us in our personal checking accounts, we no longer get copies of our canceled checks. As a matter of fact, we just get the front page of our checks, the front copy of our checks without getting the back copy. Well, it used to be the rule in the trust account, you actually had to get canceled checks. Well, the Florida Bar has gotten progressive with the rules and no longer has made that a requirement. But you still, and this is distinct from what you usually get in your personal account, you have to have your bank send you not only the front part of the canceled check, but also the back part of the canceled check. That record must be maintained so we can see the endorsements. The Florida Bar can see the endorsements if you ever were to get audited. That's just the rule. You have to maintain both the front copy and the back copy of the canceled check. So you need to get with your bank and ensure that they are sending that to you on a monthly basis when they send your bank statement to you. As part of this agreement too, and it puts a burden on your bank, if ever there was an overdraft, then you need to avoid that at all costs. If there's ever an overdraft in this account, they must notify your bank, the Florida Bar, as a requirement of housing an IOTA account. So you want to avoid that from happening. So what did I mention? You have to have your bank statements. You have to reconcile those bank statements on a monthly basis. You also have to have copies of all your deposit slips. Not the deposit receipt that the bank received the money, but the deposit slips which list each check individually that you're depositing or any cash that's being deposited in your trust account. You must maintain a copy of those deposit slips. Wire transfer documents. The rule, read the rule, look at all the requirements under a wire transfer in and out of your account and the documentation that needs to be maintained for those items also in those transactions. And each of these records which I'm mentioning, your bank statements, your trust account checks, your backup for wire transfers in and out, also the reasons why you're writing a trust check or receiving a trust check, all these types of items must be maintained for 6 years according to the rule. As I mentioned, you need to reconcile that account on a monthly basis, not only making sure that the bank balance is reconciled, but then that balance corresponds with the various client amounts that you're holding. We used to do it through manual ledger cards. Everything, of course, is electronic nowadays. So you add all those client funds together and make sure those two amounts equal on a monthly basis. You require it once a year, but really, practically speaking, to publish a list of all your clients and the amounts that you're holding for each of those clients. I would recommend highly that that's done at the same time you're doing the bank reconciliation. When you're dispersing funds, it's important to remember that you only can disperse funds on collected amounts. What do I mean by that? That means if you receive a personal check from a client or a business check from a client, that's not a collected amount. It has to go through the banking process for that to become a collected amount. Usually it takes around 2 to 4 days for an amount to become collected. Once that amount is collected is when you can disperse against it. Now there's certain exceptions in the trust rules to allow you to disperse in a more timely fashion than waiting the 2 or 4 days. That's if you receive the money in a wire transfer in, or if you receive it in a cashier's or bank check or a U.S. government or state government check, or if you're receiving a check from another law firm's trust account, not from their operating account, but from their trust account, or from an escrow on a title transaction, you can disperse on those funds immediately. Those are considered being collected immediately. But any other types of funds received into your account, they need to be collected before you disperse against it. So you have to be cognizant of that fact when dispersing any funds from your trust account. Let's get into the area which causes probably the most problems, and that's the fee questions. And let me do it by example, probably the best way to go over how this works. Let's say, and I'm just going to make up numbers here, you're going to be doing a simple lease, a residential lease. And let's say your fee's $1,000. You estimate it's going to take 4 hours. Your hourly rate is $250. And you receive that from your client, a $1,000 retainer check. Well, that properly is to go into your trust account if that's a refundable deposit. If your client calls you up halfway through your work and says, oops, that person's not going to rent for me, I don't need the lease, please stop working on it, that's fine. At that point, when that work was done, half done, I guess, and if the funds were collected at that point, you would take your fee of 2 hours of $500 for the 2 hours at $250, and then return the other $500 from your trust account to your client, since they canceled the work being done. Now let's change that example a little bit. And that same client comes in, you're going to do a residential lease for $1,000, but this amount is non-refundable. That's the agreement you make with your client. In that case, that check for $1,000 should not go into your trust account. Since that is immediately earned, if it's non-refundable, that should go into your firm's operating account. Do not put those amounts into the trust account. So you see, you have to be very careful, and some of these rules are nuanced based on the type of retainer that you're receiving from your client. Let's change that example even further to illustrate another point. Let's say you did do the tenant lease, now it's time, that tenant didn't pay, so it's eviction time. So you quote your client a fee of $1,200, which includes the cost of the eviction, filing fee, service of process, that type of thing. So here you have a fee and you have costs both coming into your trust account. That would be proper, first of all, since it is an advancement of cost that you're receiving from your client, for that to go into the trust account. And then once the work is done, and once you would take out your fee. You would also pay out the cost of the filing with the clerk's office, or paying for the process server out of that trust account, because that's what was your agreement with your client. Now, that same $1,200 that they're paying you there for this eviction action, if the fee part is non-refundable, that's your agreement with your client, then that changes the situation. You would still put the entire $1,200 check into your trust account, but the part that you would perceive as non-refundable, let's say the costs were $300 is what you estimate them to be, and it wouldn't be exact, but you estimate $300 of cost, then you would leave the $300 in the trust account and take out the $900 as your fee after those funds become collectible. That's the way that works. Again, you could see it's a nuanced difference based on the type of fee you're receiving, whether it's refundable or non-refundable, whether there's cost or not cost included in the amount that you're receiving. Now, if you're receiving an amount for a client and you're not having this as just a short period of time and the amount becomes more significant, let's say it's a real estate transaction where you're holding $50,000 and you're going to be holding that for a year, those accounts should go into a separate trust account on that client's behalf, that the interest earned on that goes to your client. It either could be, and when you're establishing that type of account with a bank, it's very important that you indicate that that's not an IOTA account, that the beneficiary of that interest is going to your client, and that be segregated funds, so that the client does receive the interest on that money. And I could tell you, having established these accounts before, the bank will say, oh, well, you're holding that in escrow for that client, and you're going to use the word escrow. Again, tell them, no, it's a trust account, because that's what the bar rules say, and it must be listed as your law firm trust account. Sometimes they'll put under it for the benefit of a particular person. That person obviously has no control over that account. You are the one who has the signature authority over that account. You're holding it for trust for that individual, but they earn the interest on that particular account. So that's important if it's the amount which the interest earned is going to benefit to the customer and the client, and the interest earned is going to be significant enough where it's going to be more than the cost of maintaining that account is when you make that determination. It gets a little complex when you're doing that, but usually is an indicator when your client comes in, you're holding a deposit, and you think it's going to be long-term, you would set these accounts up as a separate account where the client benefits from the interest earned on the account. The important thing with trust rules is to read them and to understand them. There's some other areas, such as if there's a fee dispute, if there's disagreement as to who the money belongs to in the trust account, the rules talk to each of these items. You also get into the issue of an amount that stays into your trust account for a while, and the owner may become unclear. Let's say it was a corporate check, that corporate entity no longer exists. Those are real things that happen. And then you have to go through certain processes to find where the money should go to. And if it ends up as funds which no one can be allocated, it would go through the abandoned property rules under Florida statute. And that would be your last resource there. Those things don't happen on a regular basis, so really it's best when those types of things happen that you refer to the rules of the Florida Bar and look exactly how those items should be handled. Hopefully this overview has given you some help in establishing your trust account, on the rules that pertain to it, on the record-keeping responsibility, and making sure that you stay in compliance with these rules, because we want to keep everyone from getting into any trouble concerning trust account violations. The best way is know the rules and follow them as best you can.
Some areas of concern when considering sharing office space with a non-lawyer are: first, it's important that the public be able to tell the difference between the two businesses. This is achieved by signage. It's important for the outside of the office to reflect the signage for the law firm business and the non-lawyer's business. Also, the building directory should note that there are two separate businesses within the office suite. For example, if John Smith is operating a law firm and Jane Jones is operating a real estate brokerage firm within the same office suite, it's important to denote both businesses with a separate sign. Also, if you've decided to advertise or have your business cards placed at a shared receptionist desk, it's important to have the business cards separated so that members of the public can tell the difference between the two businesses. And if the two joint businesses have decided to use the same receptionist, it's important to have a separate line and make sure that the receptionist lets the public know when answering the telephone which business they are calling. Rule 4-1.6 also talks about the importance of lawyers maintaining client confidences. So if you're sharing office space with a non-lawyer, it is important to make sure that that non-lawyer does not have access to any of your client information. This can be achieved by making sure client information and files are stored on a server that the non-lawyer doesn't have access to. If you're still maintaining paper files, making sure that your paper files are locked away so that the non-lawyer doesn't have any access to your paper files. And lastly, making sure that when you're meeting with clients, whether it be via telephone conference or in person, it's important to make sure that the non-lawyer is not able to overhear any of the conversations you're having with your clients. It's important to note that you are prohibited from soliciting clients or using another to solicit clients on your behalf, and you're also prohibited from sharing fees with non-lawyers. Reviewing Rules 4-7.4a and Rule 4-5.4a are important. It is also important to make sure that supervision of the non-lawyer is paramount. You want to make sure that they are not engaging in the unlicensed practice of law, and also that they are not misrepresenting their relationship with the attorney if they have the ability to meet with clients prior to them seeing the attorney.
Hi, my name is Chad Burton. I'm CEO of Curo Legal and the founding attorney of Burton Law, a virtual law firm. The issue that we're talking about today is whether you need an actual office as a lawyer for running your practice. As I mentioned, I have founded and run a virtual law firm which has used minimal office space since its existence. And this is a hot topic in the virtual law practice world, whether you need an office or not. And there's different schools of thoughts, and it really comes down to a lawyer type answer. It depends. What type of client are you serving? And so if you are starting a new law practice or have an existing practice and you're thinking about cutting back on office space, you look at your types of clients that you represent and perhaps even how you currently interact with your team. So going at the client issue first. I, through my law firm, represent primarily businesses and tech companies all over the world. So in my home place of Dayton, Ohio, my clients aren't necessarily present, and even if they are local, they don't really want to come to my office. They're busy running their business. Now, if I had more of a consumer-facing side practice, this is where the analysis changes. If you have a client base where they need to be able to walk in off the street, whether it's scheduled or not, or that is a more comfortable way to work with your clients on a regular basis, and they need that, and they feel perhaps there'll be something missing from the service you're providing. That's really the core of all of this. Regardless of how we're looking at structuring a law practice, it is about serving your client and the best needs there. Now, I mentioned also how you collaborate with your team, and that is an evolving concept where folks are used to being able to walk down the hallway and poke their head in and talk to others and discuss issues. But with technology now, there's so many ways to collaborate real time that need for face-to-face interaction with a team is becoming less and less. So at its core, when you're looking at whether to ditch office space or if you're starting a practice, whether to get office space, it really depends on your type of client and the atmosphere you want to go with. Now, the last thought here is there are so many options now. You don't have to go rent a full-time space. You can use a place like Regis or Da Vinci where you can, it sounds a little seedy, but you can rent by the hour as you need it. And so you can scale your use of office space by the number of meetings you have in your client base, so it scales along with the growth of your practice. So those are some thoughts on whether you need an office or not.
You know, what's interesting is that when I built Rocket Matter and I coded the first version of it, the interesting thing is that I didn't know that it belonged to a category of software, which is called legal practice management software. I just thought it was stuff that made sense because what we did was we went into a law firm and saw how people worked, and we designed the software based on how they worked. It turns out that we belong to a category of software called legal practice management software. And so the question is that why should a small law firm use this as opposed to kind of putting something together out of QuickBooks and Word and things like that? And it turns out that the people in the state bar associations are really behind us, which is something that I did not know. So this little snippet, I'll just read it aloud. Practice management software provides attorneys with a convenient method of effectively managing client and case information, including contacts, calendaring, documents, and other specifics by facilitating automation in law practice. This comes from a very valuable resource called the ABA LTRC. It used to be called the LPM section, but it's now called the Legal Technology and Resource Center, I believe. They're the people that run ABA Tech Show. Great show, by the way. Very, very informational show. And they have a lot of good information on the ABA LTRC site. It's a section, if you dig tech, if you want to get involved, they're always looking for people. So that's where this article comes from. Now, the number one advantage from the perspective, when the state bar people reach out to us, the number one advantage for them is that it reduces errors, okay? Oh, the humanity. So the number one reason that attorneys get in trouble is because of trust accounting, okay? I don't like to talk about this kind of stuff that much because I don't try and sell my software through fear, uncertainty, and doubt. But my point here is that this is why the state bars push us so much, is because it reduces risk for trust accounting issues. It also reduces the risk for calendar deadlines and document errors, conflict checks, all the kind of things that people can get in trouble for. Okay, now, so this article was written by good friends of ours at Mass LOMAP, and it's a little hard to see in this room, but it says the antidote, and by the way, the links are all here in this presentation, so if you need them, I'll send them to you later. The antidote to malpractice risk is through technology, specifically legal practice management software. So state bar people and the practice management advisors really view our breed of software as something critical for people to help reduce errors. So the second advantage is that it boosts revenue. And we kind of already talked about this a little bit before. It's kind of like, you know, the profitability, the P word. But you know, as much as it may be unpalatable to talk about the business side of the profession, it kind of is very important. And in my opinion, it is an indicator of your success with your clients. So, because let's think about it, actually, if you move more cases through your system, then you're helping more people, one thing, and if things get closed faster, then you're helping them faster. So it makes a lot of sense. And repeat business is usually an indication that you're doing a good job for people. So it's something to pay attention to. It's a better way to kind of look at it, in my opinion. So the reason that LPM software, which is the acronym, always with technology you have to use an acronym, but legal practice management software. So it streamlines operations. You'll see how easy it is to create invoices and to collect. This analyst estimates that adopting a state-of-the-art practice management application saves 48 to 96 hours per year per attorney. Of the firms he studied for a recent report, the smallest one converted nearly all of that saved time into billable hours. Houlihan calculates the likely annual return, increased revenue minus software subscription fees, between $2,264 and $21,895 per attorney, based on a national average billing rate of $234 per hour. What we typically find is that people who go from nothing to adopting Rocket Matter increase revenues on average by about 20%. And so that's substantial. So if you're billing like 10,000 bucks a month, then it becomes 12,000 bucks a month, or an additional like 24 grand a year, and so on and so forth. So that's one of the things we see, and it's just because people are tracking time better, they're more organized, they're getting the invoices out faster, and they're collecting better. It's pretty simple. The awesome thing about the Trapper Keeper and also legal practice management system is that all of your client information is in one place. But the idea of having email, documents, calendar, billing, and tasks all together, being easily referenceable, huge advantage. This is from a practice management advisor named David Belinsky. He's from a law society out of Canada called British Columbia, well, he's out of the British Columbia Law Society, and what he says is that, you know, in terms of keeping track of all your stuff, it organizes your information, keeps track of all the people in each file, coordinates your communication with all the people in each file. So the thing is, his article is like from 2002, and it's still pretty relevant. So he has a lot of good information in there. A lot of the systems that he refers to, I don't know if they're still in business, but the principles are right. And the other thing is happier clients, better service. And the reason that clients like it is because you're able to access information really quickly. Like if your client calls you and you whip out your phone and you pull up the like Rocket Matter iPhone app and you're like, okay, here's where you are with your case, they like that. They also, a lot of the systems, including ours, have client portals. So they like that they can log in and they can download documents or whatever. The other thing is that we haven't really talked about this, but there is this rule that we have that we've discovered, or at least we talk about all the time, which is that your ability to collect is inversely proportional to how fast you get your bills out. So basically the idea is that the closer that you get, the longer it takes you to get a bill out for work that you performed, the less money that you will collect. So the closer your bill goes out to the time of work that you perform, the more money you will get paid. It's a very direct relationship. Clients are going to give you more of a haircut if they see stuff on your bill that has been performed months ago. Like, it has to be relevant, it has to be applicable. So that's a major deal. Like, you want to make, that's why it's important for everything else in your firm to get streamlined and to get the bills out, because you're going to get a haircut if you wait longer, a bigger one. You're going to have to write off more. So we talked about like online bill pay and things like this. And so this is from our own legal productivity blog. We have an article on improving client experience with this kind of stuff. There's also this blog called, or this website called Solo Practice University. And there's a woman named Susan Cartier-Liebel, and she basically, I guess for a fee, you can sign up for her courses and learn a little bit more about solo practice. But she does have a blog that's freely available. And she tells this story that I guess her husband was in some sort of, I forget what the situation was. He needed an attorney. And so the attorney sent him a bill, and he asked for clarification on a bill, and they couldn't easily get it. And she goes into all the ugly details, but he ended up becoming furious with his attorneys because of the billing system that they used, or the lack of billing system that they used. I'm showing Rockameta because, again, that's the one I'm familiar with, because it is ours. But I will say that, you know, Clio is a fine product too. You know, I don't want you to think that I'm up here just, this is just the one I'm familiar with. Let me boost this. All right, so what do we see, first of all? I don't know how well you guys can see at the end of the room. So one thing is that like you have all this information at your fingertips about your firm, right? And so you can see personally like how much you billed for a day. If you have the correct permissions, not everybody can see this, you can see how much is in your trust. You can see how much is pending a subtotal, taxes. I don't know if taxes is an issue in Florida or not. It's probably not an issue in Florida, right? So, and pending total, right? So, obviously there's some jurisdictions that have to deal with taxes. So you can see all this information here. Now, there's only 3 things you have to know. All of your existing stuff is on the left. All of your new stuff is gonna be created up here through this big green button and these buttons over here. And you can find anything you want through search. That's the 3rd thing. So you have existing stuff on the left, new stuff on the right, everything else through search, okay? So kind of like what's cool about this is that you can see everything that you have going on at once through your fingertips. So you see all of your calendar appointments, you see all of your pending tasks, you see the information about the billable information in your firm. So that's your stuff from your day, okay? There's also matter dashboards. So if we visit a matter dashboard, it's everything through the perspective of a matter. Now, we have the tasks, not just for me, but for everybody for the matter. The upcoming counter events for that matter. The recent billable activity. Matter billing report. All this stuff pertaining to the matter right here. Now, one thing I want to take you through kind of a sample use case and billing cycle, if that's all right. Because I want to show you how like all this stuff is gonna play together. So one thing that we can do is we can create a new matter, right? So I'm just going to do add new matter. All right, so the client, let's make that me. Okay, the matter name, let's call this blue v white. And we'll say the matter open date is today. Okay. We also have a quick add, streamlines this process, but I just want to show you a little bit of stuff. Let's say it's an hourly matter. We can do contingency or flat fee as well. One thing that I can do is also, if I have different matter types in different practice areas, I can have different types of invoices. You know, we have customizable invoices, so you can like have an invoice for that, an invoice for this type of matter, or this whatever you need from that perspective. Evergreen retainers, things like that. Evergreen retainer is great. Does anybody use them? Okay, so we've got one person using an evergreen retainer. The whole idea of an evergreen retainer is that you have a trust balance and then you have kind of a remainder amount. So let's say that you, initially you get a check for like $7,500 for a matter. And then you have this replenishment amount so that the second that you bill more than $3,000, they have to replenish all the way back up to $7,500. So once they hit $4,500 remaining, then they get billed for the $3,000. So the trust balance is evergreen. So that's popular with a lot of family attorneys. So what I'm going to do is I want to send an email to myself, and I'm going to add. So in this instance, I'm the client. So the system knows the client's in the system and has an email address associated with it. So it's asking me which of the 2 email addresses on file it's going to use, and then I'm going to click save. Okay, so we have our matter, and what we're going to do is we're just going to add a little bit of time to it. So we can do that in all sorts of different ways, right? So one thing that we can do is we can add a task. We have, what we observed is that law firms will typically shut down for a period of a day or two at the end of the month and just like go over all their items. And what we would see is that they would go through legal pads, or they would go through email and maybe their calendar, and they would try and reconstitute their month, and they just hemorrhage like their work along the way. Then they would build the invoice in something like Word, and then they would print them out, and then they would put them in envelopes, and they would send them out. So the crazy thing that we would see is that, like, you know, people would go from like a 2-day billing cycle to like 30 minutes. Because what they do is, like, if they use the system the way it's kind of prescribed, then they start capturing work along the way. So let's say we have to research case. I'll try and type as fast as I possibly can. And let's say there is a due date. It's a task. You can assign it to different people. But I just want to show you that you can bill for things that you work on. So let's say that I worked on this task. Let's say I can run a timer if I want, however I want to capture my time. So let's say that I worked on that for 0.5 hours, okay? Oh, and I have an extra decimal point in there. And billing description is in there, research case, so great, let's click save, and then let's mark it complete, okay? So now, all right, good, I've done my research. Okay, let's say that there was a calendar event for this thing. So let's create a new calendar event. Oh yeah, this is our new user interface. All right, well, let's say we have this calendar event, for example, okay? Okay, we have this breakfast meeting. Let's change it, let's change the client. Okay, so this user, Sally Jones, I'm logged into Sally Jones, is going to bill for the hour, or for the 2 hours for this breakfast meeting. And I'm going to click OK. All right, so now this is kind of the whole idea of like billing as you work. So you have the calendar events, you have the tasks. As you go along, you're going to do things. We do this all throughout the whole system. Like if you're logging a phone message, uploading a document, creating a document from a template, any of that work, we try and remind you, okay, add your time, add your time, add your time, so that you do it as you're working. Of course, we have straight time capture. We have this little like widget right here, this little $sign buzz thing. So let's just say that review and receipt. Okay, the client matter. Let's say that it's mine again, Lawrence Sport, blue v white, and let's just add a goofy amount of time. Let's just say it's 2.3. All right. Okay. All right. Now, that's kind of like, it kind of gives you an idea of like what that looks like. The other thing that we can do in the system is that we can start associating all of our data with the system. So we can associate emails in the system. And let me go to a different matter that already has this set up just to show you what it looks like. We have this matter called the Hobbs complaint. And the Hobbs complaint has emails already linked to the system. So we have like a plugin for Outlook. Even though like we're big Mac users, most attorneys are using Outlook on Windows. So we have this plugin for Outlook for Windows where you can right click on a matter, add billable time, it saves it with the attachments into the matter. We also have something called IMAP integration, which is really just a fancy way of saying that if you're using Gmail or Outlook.com or any other kind of like web-based software, or actually pretty much any email client, that you could link a folder that belongs to a case with a matter and Rocket Matter, and then all of the things appear, and then what you can do is just, as we do with everything else, you can bill for those items, okay? So you have the ability to not only incorporate emails into the matter, but also bill for them. And the documents are the same way. You can upload documents, and then you could add time for them, and so all of that stuff starts making it onto the invoice, and all of your information is in the same place. So it's kind of like a self-fulfilling prophecy and a self-reinforcing kind of way of doing things. And the more you track, the more data that you have to analyze your firm. So it's kind of a virtuous cycle.
Are the documents and emails saved on your computer, or are they saved in the cloud?
When you upload an Outlook email to Rocket Matter, they stay on your Outlook, and they also are uploaded into the cloud. When you link with like Gmail or something like that, what we basically have is just a representation list of the emails, and you can actually click in and look at the emails, but they're still stored over at Gmail. But you can add billable time to them, and then it'll grab the subject line by default to start you with the billable description. Documents, you can upload documents into Rocket Matter and associate them with a matter. You can, we're about to roll out our integration with a ScanSnap so that when you scan something, it'll automatically show up there. And you can also, if your preference is to use Evernote or Dropbox or Box, you can link to those as well.
And are those uploaded documents in the cloud as well? Saved in the cloud?
Yeah. When you upload a document to Rocket Matter, we store it on our servers. And so you can access it from anywhere, download it. Okay. Now, one thing I want to show you is real quick the invoicing. So, because I think it's very important for people to see the power of this and why it's so crucial. So what we're going to do is we're going to go ahead and send an invoice out for this matter. So I'm going to click on this matter billing tab. And this is going to give me a little preview of what's coming down the pike. So I have these 3 items, and I can no charge them if I want to. This has taxation set up, so that's in there. And I can look at different dates if I want to, but I'm just going to go ahead and invoice this. So I'm going to click the big blue invoice button. Let me make this a little bigger. We have pre-bills. Our pre-bills are completely accurate. So if you run a pre-bill, that's okay. It's like a preview of what you're about to send out. So right now what I want to do is I want to send out an invoice. And I'm going to send it out in PDF format. Am I sure? So I'm going to click yes. I'm going to process invoice. Now what happens is that the invoice is going to be run, and it's going to be saved in our Matter documents as well. So it's doing its calculation, it's doing its thing, it's running the invoice. I can download it directly here. I can click on Matter documents. I can see that it's stored there. The other thing is that I can go to Matter billing, and then each matter has its own ledger. So I can take a look at the ledger for the matter by clicking on the ledger balance. And I'm going quickly. If you really want to take a look at this, we can go a lot more slowly, you know? And so you can see that let me make this a little bit bigger. You can see that the invoice was sent out. And it was sent out today, and there's a little email icon like letting you know that it was actually emailed to somebody, because that's how you set up your matter. Okay. All right. So this is what the client sees. It says your current invoice for blue v white. All right. So by the way, this email is customizable. You can change things. And what they do is they get the invoice in an email, and then they can download it, and they can take a look at it. And this is our default, very simple thing. Look, I'm a visual person. My undergraduate degree was in film and photography. This drives me nuts. But this is what a lot of people want to see. They want like a Times New Roman invoice. You can completely customize this. You can put your logo on it. You can change all the fonts. And most practice management softwares allow you to customize your invoice. But it's a big thing. Let me just take a second to talk about the invoice. A lot of times the invoice is your only chance where you communicate with your client over an extended period of time. So it's important that your invoice is a total reflection of who you are. So put some thought into how your invoice should look. Now we got, it's just a simple invoice. You know, there's attorney's fees. In this instance, there's no cost. It's completely customizable, so you can show all this stuff if you want to. Sometimes you have business clients that really want to see the nitty-gritty of their ledger. So most people suppress that. You don't have to show that. But basically, the whole thing's generated automatically. There's all the stuff we worked on, the breakfast meeting, the research case, the review and receipt. Now, going back into Rocket Matter for 1 second, and I'll show this to you later, but you know that little envelope by the invoice that I showed you? It'll be open now once I click on this link. So if I click on this link as a client, you're going to know as an attorney that they've checked this out, because they've hit this page and it's going to go notify Rocket Matter, and it's going to look like an open letter. So you'll see that in a little bit. But it gives you an indicator that this works. Who's accepting credit card payments now? So a small percentage. I would recommend credit card payments because you can keep them on file. A lot of practice management advisors are starting to recommend using credit cards. It reduces the friction of you having to chase down your client if you have a credit card on file. You can put together like in your engagement letter plans for either recurring billing or payment plans, things of that nature. You had a comment?
Plastic money is less painful.
Plastic money is less painful for people. Yeah, absolutely. But it is this awkward thing where it's really hard to chase down your clients for money when you're trying to help them out. The more frictionless you can make collections, the better off you will be at collections. So having credit card payments or being able to like take down their, you don't have to take their credit card per se. You can also automatically debit their thing. Our system allows for both, and I think other systems do too, but I'm not sure. But you know, if you have an account number and a routing number, you can also do the same thing with your engagement letter. We'll be like, we're just going to automatically deduct as we go along. It just has to be spelled out, you know, just like anything else with your trust arrangement. So, but if you're fearful of the credit cards and you're not sure about the ethics of them, then I can point you in the right direction and send you some articles that some bar association people have written. So don't worry about that. So I'm just going to put in some information here. All right, we'll say it's Boca, Florida. All right, I'm just going to skip ahead. We have this dummy credit card that we can use for demonstrations, which is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, and an expiration. Okay, so I'm ready to pay my bill. Oh, we need a zip code. Country, USA. Okay, am I sure? I'm going to pay it now. Now, let's go back over to the Rock Matter side of things. So this is the invoice itself. So you can see that it's open now. The client has looked at it, and you can see that the payment has been recorded. So you don't have to like enter the payment. You don't have to enter the payment yourself. It automatically updates the system, and it's going to hit your bank account either the following day or in 2 days. Usually what happens with credit card payments is like the larger they are, the more the payment processor may stiff around because they might think it's fraudulent. So if it's like a 5, and well, I mean, that's the thing is that we're not selling cigarettes here. Your transactions are going to be like 2,500, 5 grand, 10 grand. So anyhow, that's kind of how that works. So if you combine that with overall billing, right? So we just invoiced one matter at a time. You can also invoice all of your matters at once. So like in this thing, we have 27 grand of fees pending invoicing. So we can go ahead, and hang on a second, this is, let's see if I can get it to Schnoot. That's not going to work. All right. So I'm going to click Get Answer. And what the software allows you to do is it combs through all of your unbilled activities and pulls them together on a matter-by-matter basis in one list. And you can invoice all of them at once. So you can invoice all of them at once, all the emails go out with all the invoices, and they all click on their links and pay in an ideal world. So you're going from this situation, and so you've accomplished 3 things. Instead of time, you're accurately capturing your time, right? You're getting the invoices out quicker, and you're collecting a lot faster. It's kind of hard not to make more money when you do those things. So on the dashboard, there's something called achievements. So basically what we found, and I was just having this conversation with one of the attendees, the one who scanned was actually a judge who's now going back into private practice. And I was telling her that we have this mantra that if they train, they stay. Like usually the people that leave our system, because we look at that data too, usually the people that leave our system are solo attorneys, and a lot of them are just closing down. And the ones that aren't, usually, a lot of them go back to using Outlook and Word and QuickBooks. And usually what happens is that they didn't train. So we have this mantra that if they train, they stay, right? So, our training is free too. And unfortunately, like, not as many people as we would like to take advantage of the training. So what we decided to do is we decided to employ a technique called gamification. So when you first sign up for Rocket Matter, you earn your first coin. When you add a matter, you earn your second coin. When you input billable time, you earn another coin. And when you, when you send an invoice out, and so on and so on through the payment cycle. So we try and guide you through a payment cycle by like using coins. It's kind of a system that is taken from the video gaming industry that tends to work with people. And so we're interested to see how it works. But the other thing that we want to do with it is that we want to start introducing more coins for like some of the features that we don't have. Like we lost a firm recently because they didn't understand that we had document automation. They're like, I just went with another software because they had document automation. I'm like, it's hard when you have software that you constantly update to let your clients know all the stuff you have. So the achievements help us like notify people about what's going on in the system. And That was a very long answer to your question. Okay. Yeah, so we're going to be redeeming the coins for like points that you can like spend money on, like awesome t-shirts and stuff. Or whatever you want to spend money on. Okay. Cloud or on-prem? All right, so this is a big question. Software that runs like ours in CLEO, in my case, through the web browser is called, is considered cloud-based software. It runs on a server in a very secure facility, and you access it through the browser, or you have on-premise. And on-premise, how much time do we still have enough time, right?
We have another
15 minutes?
Yeah.
All right. So the leaders in the on-premise space are like Time Matters, PC Law, Amicus, and Tabs 3. So, you know, it's kind of interesting. We were the first ones out. CLEO followed us by about maybe 3 months, and then my case came along maybe 3 or 4 years later. And like, we've come a long way since then. When you're going down the path of choosing between one or the other, these are some of the considerations that you're going to have, okay? The advantages of a cloud-based system are that you can access it from anywhere. You can access it from your phone, you can access it from your mother-in-law's house, you can from wherever. As long as you have access to a browser, you can log in and get it. An on-premise system, on the other hand, it lives on a computer. It's a downloadable executable, it's installed. You know, it may have to be configured on your network or whatever it is. Usually it's a lot harder to get started with an on-premise solution. They do have advantages, so I'm not going to be up here and tell you that the cloud is the way to go for sure for you. You know, you have to be a little careful. Like a cloud thing is better if you like lose a laptop or something like that, because you just get a different machine and you just log in and you keep working. You lose your on-prem system and then you have to deal with that. Hiring new people is a little bit easier because you can just like fire up a new window and get those people going and move them with a cloud-based system. With an on-prem system, you have to get like a different license and so on and so forth. On-prem systems, typically, the advantage there is that you spend most of your money up front, and then you don't have to worry about it. That's actually how, like, when I originally priced the software, how I came up with the pricing for Rocket Matter, because I took a look at like what the pricing would be for a 5-user firm for like something like Amicus Attorney or Time Matters over 5 years, and then I figured out that $50 a month was probably around where it might be. Because usually, a lot of times you have to get a consultant involved to install those systems, and you might need another machine that has like SQL Server on them. On-premise services still have the advantage over cloud with integration with like local systems. So they like, for example, Time Matters, like we have this ability, we have a pretty sweet Outlook integration where you can right click on the email and it uploads to Rocket Matter, but you know, you still have to kind of go through that right click and do all that kind of stuff, where when two systems are on the same computer, then they can do a lot more things with each other. Sorry about that. They can do a lot more with each other, so they can talk to each other a lot more in a lot smoother fashion. So like Amicus Attorney, for example, has, and Time Matters as well, have really tight integrations with email because they are right there on the system. And they can talk to each other. We try and go around that by having things point to the cloud, and so it's getting close, but it doesn't have the same full functionality that an on-premise system would have. So that's one thing you might want to think about. The security considerations, it's kind of at a weird point right now because we're kind of approaching this tipping point where your clients are perceiving using a cloud server as possibly more secure than having a server in your server closet. Because if your server is like hosted at Amazon, like with all of their like wondrous capabilities, versus something that's in your closet that's not maybe locked, or that the janitor has access to, or that the landlord has access to, most data theft occurs physically. I do an awesome talk all about all those hacks you've heard, all about all those attacks that are in the news. Like I go through and I talk about how each one is done. And it's always really depressing because they're never that cool. The only one that's incredibly cool is the Stuxnet one. You know about that one? Where the Israelis and the Americans like hacked into the Iranian centrifuges and like set their nuclear program back 3 years. It's like total spy level stuff. That is like the coolest hack ever. But most of them, like the Sony stuff or the Jennifer Lawrence ones, most of them are like really lame attacks, really uninteresting attacks, and easily preventable. And a lot of them have to do with either insiders, Snowden, or just really simple things. So you might want to consider, I went into security there for a little bit, but the point is that you just have to kind of know what you're comfortable with. And in terms of security, Rocket Matter is a founding partner of what we call the Legal Cloud Computing Association. So, and other people belong to this, like NetDocuments belongs to it. There's a e-discovery platform called NextPoint that's on it, Clio's on it. So we were one of the founding partners, and we put together the standards document, and we did this in concert with a lot of security experts and like bar association people about like what you really need to think about when you're looking at cloud software. So cloud software security is like a whole nother session that we typically do independently. We talked a little bit about financing, that you kind of pay per month for cloud software versus all up front, typically with on-premise. And usually on-premise is going to have an annual maintenance fee too. And the other thing is that you really want to understand the terms of service when you use this software. You guys are attorneys. You're not going to be able to hide behind like a little old lady of defense or something like that, because like you're going to be expected to kind of know what you're getting into. And one thing that we see, there's a couple of softwares out there that like don't export their data to us. So we have these attorneys that are on some of these systems, and I don't think it's probably appropriate for me to name those systems, but if you want to talk to me privately, I can tell you which ones they are. Where they'll just hold the attorney's data hostage and they can't get the data out. And then the attorney is then forced to like hire a database programmer to go get the data. So, so some of the issues that you want to think about when you go to either system. Are there any questions on that stuff? Because I'm going to talk a little bit about how to get started with the last like 10 minutes or things that you want to consider before you choose either cloud or on-premise. So let's see, importing data. So, your provider should offer like a painless kind of data transition. This is like a big barrier for people switching systems because data migration is hard. So moving your data from one system to another is usually hard. A lot of times we get firms that don't really have a system and then it's kind of easy. So that's one consideration you might want to have. The other thing is that like, I don't know that it's necessarily the best idea to move all of your data to a new system. Usually what's best is to kind of move from a certain point in time. So if you're gonna, like, you have like kind of a year zero date where you're gonna do a switch over, you bring over your balances for your matters at that point and your active matters at that point, and you keep the archival, the old system around for archival purposes, for reference, and then you just move forward. That way you have like a nice clean system. We do have instances where firms wanna like load up our database with all their entire history, but we generally recommend against that because the more data you have, the more it can affect performance of a system. So you want like a nice clean system if you can. If your data is in bad shape, you should get help. And there's a whole breed of software consultants that can help you get data out of systems and clean it up. We can only do so much, you know, because we can help you with your data, we can get it in the right shape, and we can import it. But if like we get a download of your spreadsheet and in the first name field there's a semicolon, there's not much we can do, you know, and unfortunately that's kind of the case in a lot of instances. So that's one thing you need to see. That the message here is that don't like feel that there's nothing you can do, because there's always people that can help you. There's people that like make their entire careers that are specialists in the PC law database. That's their entire life. So, you know, there's people that can help get data out of a system if you really need to get your data out of a system, and we can refer you to the right place. They're very talented individuals. Okay, training. You heard me talk about this. Maybe you've heard Debbie Foster talk from Affinity. She's another speaker on legal technology. You're going to be successful if you train, if you invest a little bit of time in training. For most software providers, there's a little bit of training for free, or a lot of training for free. I mean, for us, and I know our direct competitors, Clio, there's like, well, I don't know what I know that we both have videos that you can watch and FAQs and things like that, and knowledge bases, but we also have like live training sessions where you can log on and train. So the training is not to be taken lightly. Like consider it as like part of what you got to do. I told you before, like when people don't train, they leave typically, and they revert to their old ways of doing things. So it's worth a little investment in doing it. It doesn't have to be long. It can be like, it doesn't have to be like an all-day event. It can be like an hour to get the basics down. And our system's pretty easy. Our system's very easy. It's not hard to learn, and the web-based systems tend to be a little bit easier because we rely on subscription revenue. You know, we need people to try the system, and if it's too hard for them and they give up, The on-premise situation, the on-premise servers aren't like that, because they can just, if you buy an on-premise premise solution, you bought it, you installed it, you're stuck with it. With us, you can just leave. So we have to make it easy and engaging. I don't know if that makes sense, but it's a big motivating factor in why we try so hard to make the software easy. Getting data out. This is a big deal. I talked to you about like how people have held data hostage. The other issue that you have to watch out for is, can you get your data out? If you're going to a new system, you need to evaluate this too, right? You need to think, okay, if the marriage doesn't work and I need to get my data out, can I use it again? A lot of times you can't. Like a lot of times it's in some sort of weird proprietary format. So just make sure that you can get it in at least Excel format. Ideally things like vCard for contacts. There's standards for most things. So you should be able to get your data out. When there's a standard like vCard, then according to a standard, or if not, then through other means.
My name's Teresa Morgan. I am a board-certified elder law attorney. I work on both elder law matters and estate practice. And I have been working as a solo practitioner for over 20 years. I started out in the profession when I was 24 years of age as a receptionist in a law office, and kind of worked my way up and ultimately went to law school. So I have a lot of experience working inside a law office, you know, doing the administrative work as well as being an attorney. And during that period of time, I've learned a lot of, what I think are really useful tips on hiring your first employee, hiring any employee, but right now I want to talk about hiring your first employee. So I think the first question that you have to answer is, do you really need administrative help? Look at how much you're working on things like making copies, preparing documents, answering the phone, are paying bills. Are those kinds of things keeping you in the office at night, on weekends? Do you have enough work, client substantive work to fill up your workday? If you've got enough of that kind of work to fill up your workday, it's my opinion that it's time for you to hire an assistant, because you're going to be spending a lot of time on doing those administrative tasks that you could actually be spending on paying work. So let's think about it pretty seriously at that point. I don't think you should focus so much on whether you have enough money to pay an assistant, because if you can fill up your days with paying work, you're going to have enough money to pay an assistant. If you don't, I suggest that you change the focus of your analysis as to the question of why your recurring income isn't greater. Next, I want you to think about what you need in an assistant. Do you need an experienced legal secretary or paralegal? Or do you need someone who's going to perform basic administrative tasks? Unless you have substantial experience yourself in doing all of these things, including the secretarial and paralegal work, I suggest that you need a basic administrative assistant. That may seem incongruous, but the reason I believe this is because unless you have experience doing all these tasks yourself, you're not going to be a very good supervisor for someone else, number one. And number two, there are going to be times when you have to do all these things yourself. So you need to know how to work the copy machine. You need to know how to send a fax. You need to know how to work the Microsoft Office components on your computer. All these things you better understand how to do yourself before you hire someone to do them for you. My third tip is to consider hiring part-time. Hiring someone to work Monday through Thursday is a great perk for an employee. Everybody loves to have Fridays off. As a matter of fact, for the last 10 years, I've closed my office on Fridays. Now, not everyone can do that. Some of you have heavy trial practices, you have to go to court a lot, but you probably don't really have to have that administrative assistant on Fridays. I would suggest that this is a great way to find a better employee, probably for less money, is just by working Monday through Thursday. Also, my suggestion is to pay them hourly rather than a salary. You won't run into overtime problems because they're only working Monday through Thursday, so you're going to be working well under the overtime threshold. I've got a fantastic team, all of whom work Monday through Thursday. They've been working for me for a very long time. That's not only because I'm a great boss, but that's because they have Fridays off. Next, you need to spread the word. Tell everyone you know what it is that you're looking for. Your clients, your friends, your colleagues. One of the best tips I ever had was calling our local churches, talking to the church secretary and letting them know what you're looking for. They know everybody in the congregation, they know who's looking for work, and they know who's really good. I like the online service Indeed. That's a great way to post a hiring ad without having to pay any money. Nowadays, people are looking on Indeed for employment. I do not like putting an ad in the newspaper. It's expensive, and you're going to just be inundated with useless resumes. Always tell the person who's applying to fax or to email the resume to your office along with a cover letter. Do not give them your telephone number, because if you do, you're going to be inundated with telephone calls, and you'll just be answering these phone calls all days with inquiries. So spread the word to everyone you know. Let them know exactly what it is that you're looking for. When you have narrowed down the resumes, you've performed the interviews, and you've decided on the 2 or 3 best candidates for the job, now's the time you need to run some tests. The first test that I strongly recommend that you run is called the Kolbe Index Test, K-O-L-B-E. What Kolbe does is it evaluates what your natural instincts are. So for example, are you the kind of person that when you're given a question or you have an issue that you have to dig in and find out everything there is to know about that issue before you can answer the question or move forward? Or are you the kind of person that just has an idea and moves forward very quickly with it? Are you really good with computers and technology, or are you terrible with that? Kolbe assesses what your natural strengths are in these different areas. Take a tip from me. You want an assistant that has really good follow-through. Follow-through means when they start a project, they finish a project. Most entrepreneurs are really good at starting things. They're big idea people. They're not so great at finishing things. So you need an assistant that's going to follow through. You also need someone who's going to be a bit of a fact finder, someone who's going to dig into the issue and find out about it, but not just get stuck on it, then actually finish the project. You don't want what is called in Kolbe a quick start, and that's someone that just keeps finding different things to start and never finishes. The next thing that you need to do is you need to do a basic skills test. Believe it or not, there are still people out there who are applying for jobs, and they're fairly young, but have some experience and don't know how to type. I almost hired an employee last year before I learned that she didn't know how to type. I sat her down at the computer, and all of a sudden she was hunting and pecking. That's not going to work for an administrative assistant. Do some other basic skills tests. They need to know how to use Microsoft Outlook and Office. All of the components of that, you're going to need a lot in your office. Finally, do not fail to do a background check. They may look and they may act like they are perfectly trustworthy, but you're not going to know that for sure until they've been working with you for quite a while. But you definitely want to make sure they don't have any kind of criminal background. Your employees are going to be exposed to very sensitive client information, so don't fail to run that background check. Of course, a really big question that I'm sure you've already thought about is how much am I going to pay this assistant? So, of course, you need to determine what the pay is going to be and what the benefits are going to be. There's a really great service out there that's just www.salary.com. That's a great place to go to find out what the salaries are in your community for the different types of work that you're looking for. Another thing to do is just talk to colleagues in your community. Find out what the pay range is for them and their law firms. My suggestion is to start low with what your offer is, do an appraisal and evaluation after 3 months, give a little bump to the raise, and then do another one at about 6 months. After that, do your reviews annually. do not fail to do a thorough review of their performance. That is a great time for you to have a conversation about what's working for you, what's not working for you, and also what's working for them. Maybe you aren't giving them enough instruction. Maybe they need to have more training in a certain area. You really need to keep that line of communication open. Make sure that they're dressing appropriately for your office. Make sure that you're talking about things like how to answer the telephone. Those are the kinds of things that you really should have in some kind of employee manual. You can also find them online. Now, I don't provide health care benefits. As I was telling you before, all of my employees work Monday through Thursday. They're really pretty heavy part-time employees, meaning they're almost full-time. But I do provide a number of very valuable benefits in addition to the fact that they've got Fridays off. One of those is that I close my office during the Christmas holidays. I've always closed my office for over a week during Christmas and New Year's. I have the kind of practice that I can do that. I don't go to court very much, so it is manageable. Everybody loves having those holidays off. No one wants to be in the office during that time. I pay everyone for their normal work schedule during that time. And that's another one of those perks that keeps my employees long-term. They're not going to find that somewhere else. Even though they're working part-time, I give them vacation days. I just base them on the number of days that they typically work. After they've been working with me for a year, they start getting vacation. One of my big tips for you is don't give year-end bonuses. I'll give you a little story about that. One of my first jobs was as a legal secretary in a fairly prominent law office in Tampa. They had always given year-end bonuses to their secretarial staff. The first year that I was there, the bonuses were less than they had been the prior year. The secretarial staff complained. I never thought they would stop complaining about the fact that the bonuses were so low. Now, these were gifts that they were being given at the end of the year, but to them, it was an entitlement. I think that's a wrong way to think about a bonus, and I think that it had kind of been set up for them wrong because they felt like they were entitled to it at the end of the year. And you may not always be able to pay that bonus, so you don't want to get your staff accustomed to it. I'm not opposed to bonuses. I like to give bonuses when my employee has really accomplished something that is going to benefit the firm greatly. Then I give the bonus for that specific performance or that job that they've performed over a significant period of time. Finally, and I think most importantly, you need to give thanks. You've got a great new employee. She or he has been doing a great job for you. They've been answering your telephone, they've been getting your documents out, running your copies, managing your calendar, and you're not having to do all these things. You need to express your gratitude to them on a regular basis. I'm telling you, nothing goes further than telling an employee specifically what they've done to make your life a whole lot easier. They're going to appreciate that, believe it or not, sometimes much more than a cash bonus. Give thanks on a regular basis, and you will keep your staff and you'll keep them happy. Now, obviously, there are a lot of state and federal laws that apply to employment. You want to make sure that you check those out. You can go to the Practice Resource Institute website. You can also hire a payroll service. I use a service called Payout USA. They not only make sure I'm in compliance with all of the regulations, but they actually handle the payroll for me, so I never even have to touch the checks. It all just comes right out of my bank account on a bi-weekly basis. So just make sure that you're in compliance with those rules, and good luck with hiring. I hope that you find a great staff member, and I hope you keep that staff member for a long time because she or he is going to be integral to the success of your practice.
Hi, my name is Brian Callenhoven with Callenhoven & Associates. We're an agency located in Florida that specializes in professional liability insurance. And I've been given the opportunity to speak to you today on how to purchase professional liability insurance, not only for a new attorney that recently passed the bar and is going to practice on their own, but also an attorney that might be with an established law firm that's made the decision to branch off and start their own law firm. So if you could bear with me, I know this is a fun subject, but the information I'm going to provide with you today is intended to enable you to purchase the insurance efficiently so you can move forward with starting to practice law. You've now, whether, like I said, you've now passed the bar exam or you're leaving a law firm, it's good that you know the terminology that's out there when it comes to this type of insurance. You'll hear it referred to as malpractice insurance, lawyer's malpractice insurance, lawyer's professional liability insurance, E&O insurance, errors and omissions insurance. When you hear those terms thrown at you, you'll know immediately that it's all one and the same. It just depends on who you're talking to and how they're referring to it. That way it avoids you having to ask people, wait, is this the right insurance I'm applying for, and such. So know those terms when you start the process. The other thing you want to understand is why do you need the insurance? Several reasons. One is if you're practicing law and you actually have a claim that you want your client or clients to be made whole as best they can. That protects your reputation out in the marketplace. Another reason is you might have a client or two or several that require you to carry professional liability insurance, and it's important that you know up front exactly what limits they're going to require you to carry so that you can purchase the right limit at the beginning. If you're going to be wanting referrals from the Florida Bar, local Florida Bar Association, they require that you have a minimum of $100,000 per claim, $300,000 aggregate. So you need to have insurance to obtain those referrals. If you're accepting referrals from other law firms, you'll notice on the applications that they ask if you take referrals from other law firms. Those other law firms are going to require that you maintain professional liability insurance at adequate limits. And we'll talk about that later on in the presentation. In addition to that, if you're referring out to clients, you'll want to do the same. You'll want to make sure that the firms that you're referring to maintain professional liability insurance. Now, to get the process started, you're going to want to establish who you're going to work with, be it one broker or two brokers. We don't recommend more than two because there's not a lot of insurance companies out in the marketplace that are insuring small firms for professional liability insurance. So you don't want to get too many people involved that are going to be stepping on each other and they're going to be coming back to you, with complaints that I got blocked at this market or this market. So keep it very simple. Ask your peers who they're dealing with. Ask if you're dealing with a law firm consulting that helps small firms get started in their practice, ask who they recommend. I stay necessarily away from the internet because that can get very confusing because you're going to be thrown agents from all over the country. So the best thing is to stick with your peers, ask who they are. When you've identified a couple of brokers, interview those brokers as your clients are going to interview you. Okay, so ask them questions. See if they're knowledgeable in the areas of professional liability insurance. Ask them how many law firms they're currently working with for professional liability insurance, so you know that they're going to be able to educate you properly. Once you've established those ground rules, you want to ask them to provide you with a list of carriers. If you have one broker that you're a little bit more confident in than the other, give them the first opportunity to give you 2 or 3 carriers that they want to shop on your behalf, and then give a couple, 2 to 3 carriers to the other agent, and then let them go out and canvass those carriers to bring you quotes. Makes it much more efficient. Another thing I'd ask you to do is don't complete multiple applications. If you've established a broker or two, complete the most thorough application you can, and then once that's completed, you will turn that application over to both brokers and have them go to the market with the same application. Now, once the process is done and you've selected a carrier, it could be that that carrier requires their own application, so you may have to complete one more application, okay? But that will make the process for you much more efficient, and you know that the information going out to the marketplace is the same for all the carriers, okay? Before contacting anybody, though, let's go to that process, because you want to have as much information on the front end when you're having that conversation with a broker than having to follow back up with them later. So First thing they're going to ask you is, what are the areas of practice that you're dealing in? And it's got to equal 100%. So if you plan on, and you never know what the future holds, but just starting out with a new policy, you really want to make a best guesstimate of what you're looking to target, what areas of practice. For example, if you're going to go after personal injury, plaintiff, criminal defense, maybe some family law, you want to give an idea that I'm going to try to do 50% in the personal injury plaintiff area, 40% in the criminal defense, and 10% in family law. So it's going to equal 100%. Now those numbers could change during the year, and that's okay. You need to track those percentages. So when you come up for renewal, you can provide the actual areas of practice percentages for that previous year so that they can adjust the rate or do whatever they need to do on the next renewal. Okay, so know, you have an idea of what you're going to do. You're going to need a backup attorney if you're a solo. So reach out to some of your peers that might be practicing, ask them if in the event of your extended illness or you're out on vacation for an extended period of time, that you have a nice backup that can come in and take care of any issues while you're away, so that things don't get out of hand at your practice. So, and you want to make sure that that attorney also maintains professional liability insurance. Then look at your practice internal procedures. Are you going to have a case management system? Are you going to have a computerized docketing system? Are you going to have a computerized conflict of interest systems? These are questions that the agents are going to ask you so that they can get an idea of how computerized your firm's going to be. That helps with your premiums, so they can give you a better estimate. Will you be using engagement letters, non-engagement letters, declination letters on a regular basis? Most carriers would like to see you using those letters 90% of the time, and certainly 100% of the time is the best. Will you have support staff, or will you just be working by yourself? Some carriers, if you do not have some type of support staff to be a second set of eyes and ears, they may not offer quotes to you, so that's important for you to tell the agent before they send your application to a market that's just going to turn around and decline you because you don't have a secretary or an assistant. Will you be sharing office space with another law firm? There'll be some questions that come into that. If you have separate signage, are you distinguishing yourself from that other law firm to make sure that you're not going to be brought into a claim involving that other law firm, and vice versa? If you've been in practice and you're leaving a law firm, it would be good for you to have handy your 5-year claims history and disciplinary proceedings history together, so that you can provide that to the brokers up front so they can take a look and know what strategy they need to take before they even send your information out to the carriers. Okay. Next step is determining what limits and deductibles you're going to require. This gets a little difficult for a new attorney just starting their law firm, because of course you have a lot of expenses, and we found that most attorneys that are starting a firm tend to start off with a little bit lower limits, and then as they renew each year, those limits are going to increase as the complexity of their law practice increases. But that's something you talk to your broker about. Again, determine limits could be, as we talked about early on in the presentation, it could be a client that's requiring you to carry a certain limit. Like, for example, if you're going to be doing real estate closings, the title companies out there require mainly a minimum of $250,000 per claim. There are some other title companies that require you to carry $1 million, or they require you to carry a limit that's equal to the largest closing you're going to handle for them. So you really need to find that information out on the front end before you purchase your first policy, find out what your client requirements are. For small firms, we recommend carrying a $5,000 per claim deductible or less. The savings for higher deductibles just isn't enough to justify you taking on more out-of-pocket exposure in the event you did have a claim. So I can tell you that the average limit carried by law firms in the state of Florida is about $1 million per claim, $1 million aggregate. Again, just starting out, you might start off at a lower limit and then look at bumping that up at renewal. But something you need to keep in mind is these are claims-made policies, and the very first year that you start off buying professional liability insurance is going to be at its least expensive premium. Every year you renew that policy for the first 5 or 6 years, depending on the carrier, you're going to experience a step rate increase because you're adding on additional year of prior acts coverage. For example, if your premium the first year is $1,000, when you renew your premium going into the second year, they're going to charge you another $1,000, and they're going to surcharge you 50% for that very first year of coverage. So going into year 2, your premium automatically is going to be $1,500. Going into year 3, they're going to charge you $1,000, surcharge you for that second year, which is $500, and they're going to continue to surcharge you for that very first year of coverage, probably $200 to $300. So you'll see your premium in year 3 go up to $1,700, $1,800. I'm telling you this because that's not explained enough out there. So we get calls from attorneys that are upset their premiums are increasing, but they just haven't been explained properly the claims made factors and the step rate factors of renewing your policy every year. I give the example of, imagine a basket in the middle of your room, and every day you practice law, you're throwing risk into that basket, so the chances of a claim arising out of that growing risk is going to get greater each year you continue to practice. That's why the premium goes up. But after about 5 or 6 years, that starts to level off, and then you're going to get into some other factors that may increase your premium, and that's going to be adding attorneys, if you had any claims or disciplinary proceedings, issues, that's going to increase your premium. And if you shift your areas of practice, if you start off in a low risk area of criminal defense and you eventually transition into personal injury plaintiff, you're going to see your premium go from very cheap to very expensive real quick. But it's all relative. If you're successful with personal injury plaintiff, you're going to make more money, so your premium is going to be higher because there's greater risk. Another issue that I'd like to share with new attorneys just getting started is make your shopping process about a 3-year minimum process. In other words, don't shop every year looking for a cheaper price, because underwriters really want to see attorneys have some type of longevity or loyalty to the carriers. They'll give you the best premiums if you stick with them. If after 3 years you want to test the market, that's the time to do it. Make sure you still have a good premium. If somebody comes in real low, then at that point you get with your broker and you make a decision as to whether or not it makes sense to move carriers. But it's an expensive, time-consuming process, and our recommendation is to not do it every year. Do it every 3 years at a minimum. Okay. That's about it, guys. I hope that these steps that we've gone through help you to efficiently purchase professional liability insurance. It's a very complicated area, but knowing these tools and having conversations with your brokers and having this information together, I guarantee you will make the process go a lot more quickly and efficiently so that you can move on to practicing law. Thank you very much.
Many attorneys are afraid to use social media because we don't know how the Florida Bar advertising and ethics guidelines apply to our personal and professional social media use. But never fear, the Florida Bar is here. In 2013, the Florida Bar published its Florida Bar Social Networking Guidelines that help to tell us how the existing Florida Bar advertising ethics rules apply to our personal and professional social media use. Now, as you can imagine, there are a lot of rules and a lot of comments to these rules, but let me see if I can distill the main rule down just very quickly, and that is, well, generally, if you just have a social media profile that is used solely for social purposes to connect with family and friends, well, you're in good luck because your profile is not governed by the Florida Bar ethics rules. However, my question to you is, if you list yourself as a lawyer on your Facebook profile, or if you maybe put the office where you work in, maybe your profile is not completely social. And so my advice is to presume that your profile must comply with the rules. And if it has to comply with the rules, then you have to make sure that if you're posting an advertisement on your Facebook page, you have the required content, which is your name and your law firm's name and the office in which you locate. If you're going to publish something about your characteristics or skills, or about a past result that you obtained for a client, it must be objectively verifiable. That means that you have to be able to demonstrate and produce facts to support the result that you obtained for a client or your particular skill set. So it's okay to say that I have represented clients in social media, internet, and intellectual property related cases, so long as I can demonstrate that. What I might not be able to say is that I have successfully represented clients in several cases, because it may not be objectively verifiable what is successful and what is not. Another rule is about solicitations. So the Florida Bar says that we can't have a direct solicitation with someone unless they are a current client, a former client, a family member, or another attorney at the bar. And so the same rules apply on social media. That means I can share content on my Facebook timeline or on my Twitter feed about my area of practice and articles that I've wrote, but I can't directly message someone to try to solicit them for business unless they fall into one of those aforementioned exceptions. Now, of course, there are other rules and other guidelines, but I hope that this provided at least a primer on how our Florida Bar ethics rules apply to our social media use. And if you need any other additional information, visit the PRI website, where you can find a copy of the Florida Bar social networking guidelines and other rules. Thanks so much.
One effective way that attorneys and law firms can market their practice on social media is to share their current marketing activities to a large online audience on Facebook, Twitter, and LinkedIn. Attorneys write blog posts, publish articles, or do fantastic things on the community. So the key is to take the things that you're already doing, your press releases, your articles, your attorney marketing videos, and share them online in an engaging way that takes people from where they are on social media back to your law firm. But be careful, because all of the attorney advertising ethics rules apply on social media. This includes advertising, solicitation, and even the attorney-client privilege. Now, hopefully, we've got you excited about Twitter. Let's show you how you can create an account. You visit www.twitter.com. You can set up your account with your name, email address, and a password, and you'll create a username of 15 characters or less, and then take the Twitter tour to create your own profile, learn how to use the platform, and begin connecting. Here's how it works. This is the Twitter homepage. You'll type in your information on the bottom right and choose that username and password. Once you do, you'll start Twitter's intuitive tour to show you how to use the service. So let's walk through it together. Let's say that I've searched for the Florida Bar. Twitter will suggest to me different people who are already on Twitter that I may want to connect with based upon those keywords. And as you can see, once I typed in the Florida Bar, Twitter has presented a list, and there's the Florida Bar at number 2. Twitter also suggested hip-hop artist Flo Rida when I typed in Florida Bar, and as far as I know, Flo Rida is not a member of the Florida Bar, but maybe somebody we'd want to follow on Twitter. So once we select Florida Bar, you can now see that the most recent tweet from the Florida Bar has been added to the large Twitter feed on the right. You can also find the Young Lawyers division, and once you select follow, they're added to the list as well, and you can pick the personal or professional people you want to follow. I've chosen to follow the Dade County Bar and my own Twitter profile. And yes, I also selected Flo Rida. Why not? Twitter thought it would be a good person for me to follow. Once you've learned how to follow someone, you can import your contacts directly into Twitter. And this is just like how Facebook works. Twitter will let you know which of your contacts and friends are already using the service. And you can also upload your photo just like you did on the Facebook site. And once you have, you'll get a Twitter page that looks something like this. On the left, you'll see your Twitter photo. Below that, a very short bio about you. As you can see, a lot less content than Facebook. In the middle, You'll see my Twitter feed, which are recent tweets by me or others that I've shared. And on the right, Twitter is going to suggest other people that I might want to follow based upon my interest. At the top of the screen, you'll also see a search bar, an envelope, and a quill. Those are different ways to search, send messages, and write tweets. And we're going to show you how to do just that. But before we do, let's take a look at the back end of our Twitter page, meaning what you see now is what others will see when they visit your Twitter account. But when you sign in, you'll see this intuitive dashboard, kind of like you did when you were on Facebook. The left side has a short recreation of your profile. The middle is a list of all of your other Twitter followers' updates in chronological order. And let's now take a closer look at a tweet and see what it's all about. If you follow the arrow on the bottom of the screen, we're going to dissect this tweet. So once we blow it up, ladies and gentlemen, if you ever asked yourself, what the heck is a tweet? It will look something like this. As you can see, it's under 140 characters in length, so it's a very short update. I've typed that New York courts are inconsistent on social media evidence discovery, followed by a very short link. That's a link that I embedded into the tweet so that if you clicked on it, it would take you to that article hosted somewhere on the internet. I've put via the @ and then PO_ST. That means that I'm sharing someone else's content and I have mentioned them in the tweet. And then I've used hashtags, hashtag social media law and hashtag SM law. The reason that I've done that is if someone clicks on that hashtag, it will take them to more tweets that talk about social media and the law. So one great way that you can use Twitter to establish your reputation is by sharing content and using hashtags that are relevant to your users. So that when someone goes to Twitter and searches for something like social media law, tweets like mine will pop up. It's a wonderful way to introduce you to people that you may not know who are interested in what you did. Twitter enables users to share information up to 140 characters in length, called tweets. Twitter users can receive updates and interact with others who share similar personal and professional interests. And Twitter is not just for teenagers. Oftentimes people say to me, Ethan, how can I use Twitter to promote my practice? Isn't it just a tool for teenagers to post what it is that they're doing or taking pictures of their lunch and putting them online? Let's face it, some people do use this tool for those type of purposes. But Twitter has had a tremendous impact, not only on how we communicate in this day and age, but also on the world. And if you don't believe me, check out this video we've prepared just for you.